I appreciate a lot of what you just said there, but we have to analyze our Establishment Clause precedents first, because I think the district court said that the district's sole reason for doing this was to avoid an Establishment Clause violation, right?
That is what the district court said. That was incorrect, Your Honor. But also,
let me just take it there for a second on the Establishment Clause point. The Lemon endorsement test, we haven't applied. I don't think that is a test anymore. We haven't applied that in 2 decades, and so I don't think that helps on the Establishment Clause side. On the schools cases, Santa Fe ultimately, I think, is the case. And Mr. Clement was saying this goes beyond Santa Fe in terms of extending the Establishment Clause because it's not over the public address system. It's not the same facts situation that we had in Santa Fe, where it was to everyone in the crowd by the school over the public address system. So we shouldn't, I think he's saying, shouldn't extend Santa Fe, which itself extended Lee versus Weissman, which extended Engel. We shouldn't extend it further to this situation. Can you respond to that?
Certainly, Justice Kavanaugh. In the first instance, yes, this situation is different because this is the coach. That was a student speaker in Santa Fe, and that has to make all the difference in the world. It's not. It doesn't mean that a coach has no free speech or free exercise rights, but it does mean that the pressure to conform at that moment of those critical post-game speeches, and with a 7-year, excuse me.
Wouldn't those cases suggest so that there's a difference between the coach in the locker room? I got it there. The coach in the huddle, I got it there as well. But when the players are dispersing after the game, I guess I'm not sure how it's that much different from Establishment Clause perspective than Justice Barrett's hypothetical about the coach who is part of a group that has meetings off campus. I guess I'm not sure from Establishment Clause purposes how those two things are distinct.
Well, in the first instance, this wasn't after the students were dispersing. That was when Mr. Kennedy had prayers from September 17th through his demand letter on October 14th. And what that demand letter said is, I've had a practice that didn't substantially change for 7 years, and I want to continue that. And he spent what's a page and a half in the joint appendix in that letter saying, and students have to be able to join there too. Take the 10-26, the last game, as an example. We don't even have to go to homecoming where the crowd stormed the field, but Mr. Kennedy there went out.
This wasn't, I'm sorry to interrupt, this wasn't, huddle up team, which is a common coach phrase. That wasn't this, right?
No, but does the coach have to say that for the students to miss that? And there's something else going on too, which gets back in part to government speech and in part to in part to the religion clause concerns, is that what Mr. Kennedy did at that October 26th game is he ahead of time gave special permission to 2 legislators and some other people to come onto the field to have a prayer circle with him on the 50-yard line. It was fully visible to students, and then as part of the arrangement was to turn around and have one of those state legislators address the team, which he did.
Mr. Caskey, let me ask you to give me your